Adopt the agenda. We need a mover. Paul,
Yeah, I'll move so.
anybody got any problems? All in favor? Carried. Adopt the minutes from April 26th. Larry? Uh, Any questions on the minutes? No question, all in favor? Now we got our delegation. Gonna introduce him, Darcy Allen, and we'll have introductions. Go ahead, Mike, Gary. We'll start with Quentin and go around that way.
Quentin Beaumont, Manager of Agricultural Operations.
And Richard, Director of Municipal Services.
Darcy Allen,
Yep. Darcy Allen, Farmers and Property Rights Advocates Office.
Larry Hayner, County Resident.
Michelle Hoover, Legislative Assistant.
Larry Gender, Board Member.
Warren McKay, Board Member.
Larry Clark, Board Member.
Dave Brewer, Chair.
Justin Stevens, good afternoon. Kenny Snyder.
Nikki Thorstensen, Communications.
Welcome, go ahead.
Go ahead. Okay, just want to see if this works. Yep. Perfect. Thanks for the invitation today, Chairman, board members. Capturing all of the aspects of renewable energy into one session is a challenge, to say the least, if not impossible. But I'll try to keep my remarks to some high-level information to just encourage you to maybe learn a little bit more about the industry. And I need to point out, as a disclaimer right off the get-go, is the Farmers and Property Rights Advocates Office is neither for renewable energy development, nor are we opposed to renewable energy development. I just want to mention a few things here today, just in case somebody happens to tap one of your ratepayers on the shoulder or comes and talks to you about the possibility of wanting to host a renewable energy development on your lands. And maybe some of the information you gather today will allow you to make a more informed decision as a result. So just a little bit of background for those of you who are not familiar with Farmers Advocates Office. Really, our mission at the Farmers Advocates Office is to create that value for rural Albertans. So we act as a resource for Alberta's farmers and ranchers and rural landowners, and try to empower the rural Albertans through awareness on key issues, like we're doing today, through engagement and representation on some of those matters of concern, information sharing through our publications, through our website, through our presentations, through some of our engagement in public forums. And our advocacy is working with the agencies and the government departments on any legislation or regulatory change that happen to intersect with the agricultural industry. We can also work with the parties on any dispute resolution mechanisms. It's entirely voluntary. There's nothing that they must attend as part of anything mandatory. So we just try to work through and provide some unbiased ideas and advice in the process. And I kind of tell people that if you're, kind of feeling like this little guy where you're running around with your hair on fire and don't know what to do at times, give us a call.
Just before you carry on, do you want them to ask questions as you go or at the end or what?
I would prefer you hold them till the end, because I find a lot of times I say, just hang on, I got a slide on that, or just, I'll get to that. So yeah, if we could hold them till the end, that would be great. So I'm going to power through a few of these next few slides just to give you a good high-level overview in order to give you a better understanding as to the bigger picture, the drivers of renewable energy, and why some of the landowners are being approached by developers with more frequency than they have been in the past. And the first driver goes all the way back to 2015 on the Government of Alberta policy side. So at that time, they introduced the Climate Leadership Plan, and it was a strategy to reduce carbon emissions while diversifying the economy, creating jobs, protecting health and the environment. But one of the other goals was its aim to phase out coal-generated electricity by 2030 and have 30% of electricity generated from renewables by 2030. So renewable energy resource, according to the definition in the legislations, it means it's an energy resource that occurs naturally and that can be replenished or renewed within a human lifespan, including but not limited to moving water, wind, heat from the earth, sunlight, and sustainable biomass. So it's not just limited to wind and solar developments. And since 2015, we've seen a market increase in the development of both small and large scale microgeneration, community generation, and both small and large scale commercial generation. One of the next drivers is Alberta has some of the best combined resources for both wind and solar development potential. As you can see, East Central and South Central have the greatest potential, and that's exactly where we're seeing a lot of the applications for energy development. And as a rule of thumb, solar development projects require about 5 to 7 acres per every 1 megawatt of energy produced, and wind will be in around 1 acre for every megawatt of energy produced. But that, of course, really depends on the individual output of the solar panels and the wind turbines. So that's just kind of a rule of thumb. Can you say that again, that rule of thumb? 5 to 7 acres for solar for every 1 megawatt of energy produced, and then 1 acre for every 1 megawatt of energy produced from wind. Like I say, just a rule of thumb. You know, they'll have variances on either side of that. Some developers are, piloting what they call agrivoltaics now, and that's just within the same footprint where they're utilizing specialty crops or market garden varieties and those kinds of things, and trying to do agricultural operations in the same footprint as the solar. The wind energy may entertain other agricultural uses, just simply because the turbine and the pedestal itself only takes up a small portion of that agricultural footprint. Then thirdly, the cost of renewable energy development and technology has decreased significantly in the last few years. Lazard, who's a research and an analysis firm, recently released this levelized cost of energy analysis, which highlights the dramatic decline in solar and wind costs over the last 10 years, seeing wind costs falling by 70% and solar costs falling by up to 90%. But perhaps more significantly, the levelized cost of wind and solar, which is a measure that includes the cost to construct and operate, may now show that renewable energy developments are close to or have reached parity with the marginal cost of efficient natural gas power plants. So this suggests that building renewable energy power is or can be almost cheaper than operating existing fossil fuel power plants. So couple that with the clean energy tax credit incentives, carbon credit markets, power purchase agreements, a deregulated marketplace with a favorable supply and demand imbalance. They can all be further incentives for greater economics and further support for additional development. And then lastly is it's just the appetite and the growing movement and the sense of urgency of achieving a net zero decarbonized society. So renewables isn't confined to the rural landscape. This is just an example of some of the growing movement that people are starting to look at getting off grid more or subsidizing their power by putting roof mount solar panels into their energy mix. And this is just an example of the Prairie Sky Co-housing Cooperative out of Calgary that's been getting all of their electrical power supply right from their solar, and they've been doing that since 2020. Some of the pumped hydro or the compressed air or electrolysis, hydrogen production, kinetic storage systems, small modular reactors, they're all going to have or be viable in the energy mix, but they're all just really in their infancy right now. I think what's the growing concern that we're hearing from landowners is kind of alarming them is related to really the sheer size and scale of the developments that they're either being presented with or that they're seeing popping up in their community. So on the left is the 465 megawatt Green Gate Power Traverse Solar project. It's developed on approximately 3,680 acres of land in Vulcan County. There's about 1.3 million solar panels, and this development occupies about 23 quarter sections of land. On the right is the recently approved another Green Gate power development. It's called the Lunar Solar Project. It's another photovoltaic project combined of two different phases on adjacent lands, but has the potential for a combined capacity of 930 megawatts. And this one is going to be built on just under 5,700 acres of contiguous land, and this is about 20 kilometers west of Brooks. And they contemplate using 2.2 million bifacial photovoltaic modules. So this one will be one of the larger ones that we've seen come through the Alberta Utilities Commission process. The other concerns that landowners have expressed to me is with aesthetics. So for solar installations, the typical heights above ground can range anywhere from 1.75 meters to 3 meters in the air. So you can start to see these things from a further distance than you had in the past when they were mounting them, quite close to the ground. The majority of the projects currently producing are or proposed are in that 20 to 50 to 75 megawatt size. So not all of the projects that we're seeing are in those mega size that we just had on the previous slide. And the typical panels are they have an output ranging of anywhere from 500 to 575 watts each, and they can be arranged with fixed tilt or single axis tracking systems that follow the sun throughout the day, or they can be monofacial or bifacial modules that generate electricity from both sides of the panel, utilizing either the reflection off of the adjacent panels or even the reflection off of the snow cover on the ground. The other thing that is concerning to landowners once they get into looking into these proposals is it's not just the panels themselves, right? There's all of the other ancillary equipment that come along with it. It could have electrical inverters and pad mount transformers, access roads, office buildings, electrical collector systems, telecommunication and communication systems. So it's, and possibly even some storage systems. So it's not just the panels themselves, there's all of the other peripherals that may come along with it. With the new technology and design, some of the wind farming equipment or the wind power plant equipment is getting larger and dwarfing some of the initial installations that we've seen in the province, 10, 15 years ago. Some of the developments that we're seeing have the potential of having hub heights of 185 meters and rotor diameters of 170 meters and blade lengths of up to 85 meters. So these things are getting pretty large in scale. And the rule of thumb, again, you can have a turbine that has an output of anywhere from 2 megawatts to 7 megawatts of generation on each site. So like I said, it really depends on the area of land and the usage and the power generation based on the output of the turbine itself.
Those numbers are per day? The megawatts per day, or would you say megawatts?
That's the nameplate capacity rating.
Right. What unit would that be, the megawatt per what? Like it would create 7 every hour?
No, that's the over a 24-hour period.
24
So the organizational roles, just some of the high-level roles of the different government organizations that are participating in, or the agencies that have oversight of the renewable energy markets. So it's not regulated by the Alberta Energy Regulator. It's regulated by the Alberta Utilities Commission. So they're the regulator for the renewable developments in the province. So this means that they're the ones that are making all the decisions on application. And the AUC is a quasi-judicial and independent agency of the government of Alberta. They don't make any policy. Their role is to protect the social and economic and environmental interests of the province. They are governed by the legislation that regulates Alberta's energy resource and utility sectors. And the AUC sets out all of the rules, all of the requirements, and all the processes that have to be, or that are implemented and followed by the regulated utilities and the renewable energy operators that fall within their jurisdiction. And then you have the Alberta Electric System Operator. They manage the supply and the demand for electricity in the province. This involves planning and operating the provincial power grid. They are a not-for-profit organization with no financial investment in the industry. So just on behalf of Albertans, they're the ones that work with the industry partners and government just to make sure that there's reliable power there when we need it. Alberta Environment and Protected Areas, they're the primary policymaker for the renewable energy considerations in the province. They have oversight for all of the environmental aspects related to wildlife directives, and they lead the regulatory initiatives on achieving the desired conservation and remediation and reclamation outcomes. And then there's our office. We don't have any regulatory or legislative oversight. We're just like we're doing today out there talking about some of the key issues. One of the aspects that differentiate renewable energy developments from the oil and gas industry that many of you may be familiar with is that it's a voluntary participation process in hosting a power plant on your land, and consent must be gained from the landowner for them to proceed. So if you decline to participate in the development, there's no recourse for the developer to gain access otherwise. There's no forced taking, there's no expropriation or a right of entry process, like there is with oil and gas through the Land and Property Rights Tribunal. And as such, the Surface Rights Act does not apply to renewable energy. So leasing is a private bilateral commercial agreement between two parties, the developer and the landowner. And the typical heads of compensation that conventional energy companies and transmission companies observe are not applicable to renewable energy. So there's no such thing as an entry fee or land value or general damages or inconvenience, loss of use, or adverse effect. All of those terminologies are contained within each section of the Surface Rights Act that are the S12, S25, S27 references on the slide. None of that applies to the renewable energy developments. So because the Surface Rights Act does not apply, there's no requirement for any renewal notices of rent reviews. There's no 5-year cycle of a rent review process. There's no remedy for compensation through a tribunal. There's no remedy for any damage claims, and there's no recovery of compensations should the operator become insolvent, unwilling, or unable to make their financial contributions to the landowner. However, it's important to keep in mind too that if a developer has highlighted your area as a significant energy resource and you decline to host it, they may simply just jump over the fence and sign an agreement with your neighbor. Whereas you would get, just as much of the negative impacts, but potentially none of the compensation. Because the Surface Rights Act does not apply and there's no forced taking, a developer does not have to use a licensed land agent. Many have adopted that process, but it's not a requirement for them to do so. It's entirely voluntary. There's no standard agreement for renewable energy leasing. They're highly variable and different on a case-by-case basis and from company to company. Many of you may be familiar with the typical oil and gas surface lease agreement that's, 3, 4, 5 pages in length. Some of the renewable energy agreements are in that range of 30 to 60 pages in length. So they're very, very comprehensive. They can have agreements of primary terms of anywhere from 20 to 30 to 40 years with an automatic renewal provision for another 20, 30 or 40 years for a secondary auto renewal. There's few, if any, terms and conditions that allow the landowner to terminate a contract, but there are normally several avenues for the developer to do so. So in that regard, we highly recommend that landowners get a legal review undertaken before agreeing to sign any of these renewable energy leasing agreements. We don't, from our office, we don't endorse any specific firm or lawyer, but we do provide any of our clients with the contact information for the Law Society of Alberta. They have a lawyer referral process that you can call, and they'll give you the names of up to 3 lawyers. You can have a discussion with one or all of those lawyers. It's unbillable if you tell them that you contacted them through the lawyer referral process. And then at the end of that conversation, you can make a decision as to whether to, hire any counsel or not. They won't give you specific legal advice, but they'll walk you through a number of things of your options and their services and competencies and things like that.
And these lawyers they recommend are familiar with this. They're not recommending criminal lawyer for this.
Right.
It's not just you pull somebody's name out of a hat and this is the lawyer you get.
Right, you'll have to tell the lawyer referral service what area of law that you are looking for competency in. So, renewable energy contract law. And then they will have a number of lawyers that have registered for that service that have those competencies.
Fair enough. Good.
So every developer that I've talked to has no issues or concerns with undertaking the costs associated with a legal review. But if there's a developer that says we're only going to cover, legal costs up to a certain amount, just remember everything's negotiable. And from my experience, if they're unwilling to undertake all reasonable costs, then that should be a red flag. The agreement will typically indemnify the landowner from any accidents or damages during the life cycle of the development. So we recommend as well that you be added as a third-party additional insured on the developer's policy. And some of the leasing agreements and contracts actually require the landowner to carry or increase their own farm or general liability insurances as well. So if any of you are familiar with the costs associated with different coverages, that could become quite expensive. So just make sure you have a really good understanding of what you're agreeing to. Make sure you talk to your accountant to make sure that you're aware of any tax implications. Ensure to talk to the municipality because there very well may be, a redistricting or a zoning change as a result of that development, and that may impact the property tax assessments. For any issue resolution or dispute resolution, ensure that you have clarity as to how any of the conflicts that you might have going forward, how are they going to be addressed. So because there's no Surface Rights Act, they will either have to be addressed by way of provisions of arbitration in your agreement, or you're going to be through the courts on civil matters to try and resolve. The end of life obligations, make sure you star this thing in your notes, is to seek the clarity and certainty on the developer's commitment to look after the activities associated with decommissioning, remediation, and reclamation. Some will provide an irrevocable letter of credit or bonds or some, trust funds or cash collateral or some other insurance provision in favor of the landowner. And ensure the security is protected in and included in any assignments or sales to another company, and ensure that it's excluded from any bankruptcy and insolvency proceedings. Because, you have to protect yourself as a private individual because you could be on the hook for the end of life obligations for the decommissioning and reclamation of these developments. And if you don't have that security provision in place, you could be on the hook for it. So the security should also include provisions to cover off any potential default in property taxes. So as the landowner we haven't seen it yet, but they may become liable for any unpaid obligations to the municipality. We haven't seen it yet, but there's the possibility that could end up being millions of dollars a year that landowner could be on the hook for. AUC, the Alberta Utilities Commission, Rule 7, requires a proponent to provide the AUC with a statement on or an overview of how the project operator will ensure that the project holds sufficient funds to cover off the reclamation and decommissioning, but it doesn't set out any specific parameters or values or limitations or thresholds on what that security permission should be or any requirements. And ensure that absolutely everything gets captured in writing, because every one of these contracts are going to be very long-term in nature. When you have generational farming or it's it changes hand from landowner to landowner to landowner, or the company changes hand from one company to the next, the assumptions of what the commitments were and the promises and the undertakings are not valid unless you have something in writing that you can refer to at a later date. How will any access be handled throughout the stages of the development? Will you be permitted to use any of the roads? Are you going to make sure that the roads and accesses are maintained? Some of the contracts, in my view, are all inclusive. Really, they don't provide for any additional payments for crop losses or other damages. And once you sign on to that agreement, you're giving that developer exclusivity to your land. And if the base rent that you have have agreed to is supposed to cover off any of those other losses or damages or anything as a result, right? So once you sign on to that agreement, be very, very clear that those annual compensations are to cover absolutely everything. You have to have a good understanding of how the fencing is going to be undertaken, how any of the weed control, any of the biosecurity measures on your lands. Again, get it in writing. It's something that outlines very clear and detailed understandings of both parties. There may be setback restrictions. These are imposed either by the developer or by the municipality, and they may, be as a result of noise propagation or glint and glare assessments or shadow flicker or those types of impacts. And it may restrict your ability to subdivide, construct residences, sheds, barns, bins, and those types of things. Be certain and gain clarity on any of the opt-out or the termination clauses of, like I said before, there's typically very little ability for the landowner to exercise an opt-out and termination of the agreement, but there's typical several avenues for the developer. Just be aware of what those are and what triggers those types of actions. And the potential consequences of that termination to your long-term planning. So it may not be in operation for that full 20 to 30 and then an additional 20 to 30 years if they can terminate the contract early, and then, like I say, your long-term planning may be affected as a result. The developers, they do a really good job of showing you the potential for the economic gain, but that's really all dependent on a number of factors until it's proven commercially viable. So in the early stages of siting a development, there's so many variances of actually where they're actually going to site the equipment and how much of the equipment and what size of the equipment there's going to be. So you just have to be very familiar that there's those risks involved, and it's not just a dollar sign at the end of the day. There's also confidentiality clauses and non-disclosure agreements that will prevent you from discussing any of the terms and conditions with your neighbors or others. And that's because of the highly competitive nature of the industry. It's in the favor of the developer, not for you not to be able to share it with your neighbors when they're negotiating with them, or that a competitor may come in and undermine or undercut some of their negotiations. The compensation, some developers may, or aggregators, or some of the smaller developers may come out and try to option the land. So the option is just a period of time that the company spends in doing all of their studies, gathering data, whether it's preparatory to an application or to a final investment decision. And that commits your lands to the company for a period of time at a set rate. The options provide that, again, exclusivity to the developer, where no other contractual land use agreements can be entered into, such as oil and gas activity, and it may prohibit you from or restrict you from renting your land, selling your land, or even mortgaging your lands. The developer doesn't have to lease your lands at the end of the day or at the end of the option agreement. They could just walk away, or they could go adjacent to the next door neighbor. The options can be based on actual intent to develop or speculation on the land, where a broker goes out and puts together a big land package, and then they go and peddle it and sell it to a larger developer. So just be aware that whomever you're signing those agreements up with may or may not be the actual operator that you end up spending that long term relationship with. It's important to recognize that the compensation offer projection represents the best case scenario and may be overstated. So have the developer walk you through all of the scenarios of that compensation associated, and so that you have a clear and realistic view of what the actual benefit and the potential risks are. There's no standard compensation structure. They may present you with a fixed or a variable or a fixed plus a variable type of an option or type of an agreement. We recommend negotiating some kind of a fixed component, because the variable option really and entirely depends on the generation of the site. It's market driven and again, dependent on corporate decisions. So the fixed scenario is just a base renter payment paid regardless of what stage of or whether the development is in operation or not, or producing electricity. And then the fixed and variable is just a combination of both. So in this, it's very important to understand the activity timelines and the different payment structures, because the option period could be paid at a different structure than the construction phase, than the operations phase, than the decommissioning, then paid again differently through the reclamation stage. So it's very important to know when the different compensation comes into effect, what triggers it, and when it's going to be paid. Some landowners give me a call and say, how come I didn't know about this thing? It showed up in the community and there was no warning of it at all. Well, the developer is required to conduct a thorough participant involvement program that includes notification and personal consultation requirements. So under AUC's Rule 7, all persons whose rights may be directly affected by a proposed development must be informed of the application, have an opportunity to voice their concerns, and have an opportunity to be heard. So the engagement activities must be conducted with all the occupants, residents, and landowners within varying distances from the project, based on the project's type, size, and capacity of the generating facility, and whether it's proposed to be situated in an urban or a rural environment. So just in this example highlighted here, for a solar development over 10 megawatts, urban or rural setting, the notification radius is 800 meters and the personal consultation radius is 400 meters. So if you reside outside of that 800 meters, you're likely not going to be notified of the development. The other trending concern that we're starting to hear a little bit more about is with the battery energy storage systems, or you just commonly refer to or hear referred to as BESS, or battery storage. They're becoming more common as part of an application for a power plant generation or just as a standalone facility. And the idea here is really just to generate that power and store it for those times of low demand or low market prices. And then when the demand and the market prices go up, they discharge it back into the grid. The majority of concerns here are related to the safety aspects of the lithium-ion batteries and a condition called thermal runaway. So when a battery cell fails or becomes compromised, it can then spread to the adjacent banks of batteries and even potentially engulf the whole facility. So basically, without a complex and elaborate gas detection and fire suppression system, all you can do is stand back and kind of watch these things burn and just control the area around it to, limit the spread of any fire or any other hazards. One of the big concerns that goes along with this as well is with the plume dispersion of any toxic gases. So if any of you have been around any plastic fires or vehicle fires or anything like that that has an electrical fire, it's not pretty to inhale any of those fumes. And just a little bit of clarity. These two photos, on the left is a 100 megawatt battery storage site in the States. I was unable to determine who the developer was. And then on the right is TransAlta's 10 megawatt wind charger facility. It was the first utility scale lithium ion battery storage facility in the province. Renewable energy projects are designed to last anywhere from 20 to 30 years, and it's entirely possible that at the end of that lifespan, all of the equipment could be replaced when it becomes or when it reaches the end of its design. So currently the developers are advising that the salvage value of the materials will offset the costs of decommissioning. To me, that's a little bit speculative because that'll depend on the condition of the materials and the marketplace and everything 30 years from now. So take that with a little bit of a grain of salt. Some of the materials can be recycled or reconditioned or reused elsewhere, but currently a lot of it's going to end up in landfills. So unless it's repowered, the proponent will decommission the project when the panels and the turbines reach the end of their operational lifespan. And that'll include de-energizing this installation and removing all of the above ground infrastructures. The below ground infrastructure include, such things as the electrical collection systems, some of the foundations, all of the piling and things like that. And the operator is required to remove all of the below ground infrastructures to a depth of 1.2 meters for any concrete structures, and then a minimum of 1 meter for any other remaining infrastructures like electrical collector lines and cabling and such like that. So if you have anything greater than 1 to 1.2 meters that you think is going to get in the way of your agricultural operations, you need to negotiate that right up front in the original leasing agreement to either have it, buried deeper upon installation or have a contractual agreement to have it removed at the end of the life. You can't, and very unlikely will not be able to have any influence, 20 to 30 years from now. The reclamation then follows any of the decommissioning. So that'll include removing the access roads and the gravel pads and restoring the landscape and the contours and replacing the topsoil and establishing natural grades and things like that. So in 2017, it's important to point out that the Environmental Protection and Enhancement Act was amended to include the addition of wind and solar electrical power generation. So that means the footprint is now considered specified land under the legislation as it pertains to the conservation and reclamation regulations. And operators are required to conduct reclamation certificate site assessments and actually give reclamation certificates to the same criteria level as the oil and gas industry does. That's at 2010 reclamation criteria for well sites and associated facilities for the end land use. So no differently than the oil and gas in this regard, at the end of the life, the site must be reclaimed and get a reclamation certificate. So it's important to stay engaged with the developer throughout the life cycle to make sure that they're living up to their conditions, both on the financial side and on the reclamation side. A little bit of a misconception that renewable energy developments don't have much of a legislative or regulatory oversight, or really this isn't true. These are just a few of the acts and the regulatory instruments that are in place to provide that jurisdictional authority and direction to industry. So if you have any concerns about post-approval of the development, either during the construction phase or the operation phase of the power plant, you can contact the Alberta Utilities Commission and actually file a complaint. They have a simple online complaint form that you can fill out, and proponents of renewable energy have the obligations both regulatory and legal to comply with any of the orders and the requirements set out in the Commission's decisions that relates to that project. And if there's any evidence of non-compliance with any of the conditions attached to the Commission's approval, it can be addressed through the AUC's enforcement programs. In addition, these are just a few of the site-specific protocols, regulations and directives to address the impacts related to the environment, noise, solar glare, shadow flicker, wildlife, and safety for aircraft operations. So again, contrary to some belief, it's not the Wild West out there anymore. Some of the key rules to be aware of are Rule 7 with the application processes, Rule 12 with the noise control requirements, Rule 33 with the post-approval monitoring requirements, and 24 for microgeneration. Transport Canada requires that all aeronautical assessments for obstruction evaluation be submitted, and NavCan requires a land use proposal be submitted and provided as well. So what can you do? Really just familiarize yourself with the Alberta Utilities Commission's rules, the decisions on how to participate in development proposals, register and sign up for their e-filing portal. This e-filing portal is extremely valuable. It's their online tool used by the AUC to assist with managing all of the documentation and the sharing of information about all of the utility proceedings. This is the system used by the proponents to file all their application documents and for members of the public to participate or observe applications and proceedings already filed with the Alberta Utilities Commission. So any of their environmental protection plans, any of their emergency response plans, any of their application documents, any of their assessments for noise or glare or flint, all of that is posted in the e-filing system, and it's available to the public. Understand what the Alberta Electric System Operator does and how they interact and the roles that they play in the Alberta electrical market, and because they also have a lot of videos and resources too to help in the understanding of the electrical markets. Stomp around some of the renewable energy information sites such as the Canadian Renewable Energy Association and other like-minded renewable renewable energy participants. Many of these proponents have websites and have an enormous amount of information and frequently ask questions on their own sites as well. And then the government of Alberta for information on environmental protection assessments and certifications. Before closing, I wanted to just note that the Farmers Advocate's Office actually has a public document called Negotiating Renewable Energy Leases that has much of the information in this presentation contained in it. It's for landowner considerations and common questions. It's available for viewing and download. You just go to our website, navigate to the Energy Utilities and Surface Rights section, and that publication is there. We're pretty easy to find. You can reach out to us or even through a quick internet search. So if there's some energy developers that are inquiring with you or your ratepayers as to their interest in hosting a renewable energy development and they just have questions or you have questions, by all means, give us a call. We can help redirect you to wherever you need to go or provide you with additional support. And with that, thank you for allowing me to attend today, and I will take any easy questions.
First, James, go ahead.
How about some hard ones? An easy one. You mentioned aggregators. I'm not familiar with that word.
Yeah, they're aggregators. They're very small companies that go out and purchase individual parcels of land and then amalgamate it or aggregate it into one contiguous block of land to then market it to a larger scale developer.
Okay, fair enough. Have you seen the AUC? Have they done any environmental enforcement or any enforcement at all with to your knowledge? Like they've been around for a while. We've had a few of these solar projects in Alberta, and I'll be honest, I have done a little bit of research on the internet, but I haven't seen AUC do any enforcement that I've seen. Is there some out there?
Yes, and it's all posted on the AUC's website. Any of their compliance and enforcement inspection results and any of their compliance and enforcement mechanisms are all posted, like all of their investigations and the outcomes.
Okay. And I've seen some of their other stuff, but and maybe I'm not familiar enough with the solar names that are out there. So
yeah,
you see the Fortis and the ATCOs have had some issues, but okay. And one last one, if I can, Mr. Chairman. Is there any special that you know of, again, for first responders, and is there any AUC or any of these regulatories putting any kind of emergency response plan forcing of these particular, and especially on the battery side, not on the solar side, but on the battery side, is there kind of like a blueprint of a emergency response, and do we have to train our first responders and firefighters in a different, do we have to buy new equipment if we're hosting these inside our communities?
Yeah, very good question. And those are the topics that I would highly encourage your protective services or you as a municipality to enter into those discussions with the developers and ask those pertinent questions, right? Because in some instances, you may require other equipment, you may require additional training, you may require additional information, site-specific to the scope and nature of the project that they're trying to develop, right? But I've not seen, I can't think of anything offhand where the regulator has mandated or enforced any specific provision.
That's the question.
Well, it may come up as part of a hearing process where a municipality has intervened or opposed the project, and then there's usually a commitment on the part of the developer to follow through and have further discussions with the municipality to try and find mitigations to resolve that concern.
Fair enough. Thank you.
Thanks. Larry?
Yeah, the one question I have, you're talking about the batteries burning, can the panels burn?
I'm not an expert in that regard, so I don't want to hazard a guess.
Okay, because that is a question to me. We'll have sections of land covered in panels. If we ever have a fire, what is the steps? Another one, you talked about security for decommissioning. Is that back to the company, or the landowner needs to hold that security for decommissioning?
It'll be a provision in favor of the landowner. So if they put an irrevocable letter of credit in place to cover those end-of-life securities, it will be excised or in favor of the landowner to draw upon should he or she have to, look after the end-of-life obligations.
And it shouldn't fall back to municipalities.
Well, that's entirely different because the municipality isn't a party to that agreement. The municipality should also be having those engagement discussions with the developer for their own security on property taxes or those types of defaults.
And then the last question might be a harder one for you to answer, but why do these not fall under the Surface Rights Act?
Because fundamentally, it's a voluntary process. So the Surface Rights Act was put in place because the mineral owner takes paramountcy over the surface owner. So if there was to be a quasi expropriation type of a process, the government at the time said we have to have some protections in place if we're going to allow a forced taking. So because the renewable energy developments are voluntary in that approach, is if you say no, that means no. They have to go somewhere else. There's no forced taking or no quasi expropriation.
It's still, to me, it's something that needs to be relooked because it is affecting all Alberta land. So, okay, thank you.
I can provide a bit of information on how the AUC approaches the fire risk, not so much the emergency response, but they heavily look at the vegetation control factor. So limiting the fuel that any potential fire may have if there is a spark.
The lithium battery has a lot
I
of
mean,
fuel in it.
well,
If it burns.
that's for the storage facility and that's legitimate, but if you control the area around it, well, it's their storage facility that burns and hypothetically, it's not spreading across the countryside. I have a follow-up question about compensation. So you said there's no mechanism for, say, the landowner's lease payments in the case of an insolvency. Well, I'm trying to see the parallels. If there's no mechanism for lease payments in insolvency, how much faith do we have in the reclamation requirements in the case of insolvency? It seems to be the lease payments is a lot smaller cost than potentially the reclamation. Why do we have protections for one and not the other? I'm not.
So great question. Renewable energy, there's no protections for either. So your security is going to be based on, having to look after that end of life obligation for the reclamation, remediation, and decommissioning. If you're not getting paid your annual compensation, now that's going to be a matter through the courts. So it all depends, like I said, we'll go either going through arbitration or through a civil matter. Because it's a bilateral agreement between the two parties, you're going to have to protect your interests and try to go through the courts to get it. There's no Surface Rights Board for recovery of compensation. So neither one of those issues, either your annual compensation or the end of life obligations, they're not covered.
Okay.
And that one question to the taxes.
Oh,
Yeah.
I got it. Ernie next.
Uh,
How many more you got?
I got a couple, but you can start.
Okay, we'll skip
I got a
you.
list.
We'll come back to you. Okay, go ahead, Ernie.
When you're saying the costs like to produce the energy, did that include also say like that they were very equivalent? Did that also include say like the cost of the reclamation?
My understanding, yes.
Another one is say like when they go to reclaim these, say like for the wind tower, these concrete bases, are they utilizing the natural elevation of the land that they have to take out from there? Or if I was a contractor, I could cheap out, dig a dugout and fill over top of 1.2. So
Again, that's going to be a discussion that is going to happen with the landowner of what the determined final grade is going to be that you agree to. So they will only have to take it down 1.2 meters below final grade for recovery of any of those cement. If you have an agreement or they want to dig it down further to create some other kind of a surface improvement or a dugout or something like that, that's all going to be based on any of the contractual agreements or the agreements that you can come to as a resolution at the end of life.
It was not digging it down, it was actually digging a dugout to cut over top of this, so you don't even have to disturb the concrete.
But there again, it would be up to the Alberta Environment Protected Areas as to whether or not that final land use would meet equivalent land capability.
Okay. Justin?
Just to note, I've heard that it is incredibly commonplace for the companies to change hands multiple times before they produce power. Has that been your experience where it may be the third different company or fourth by the time they actually produce?
Yes, so it's not uncommon for the corporate structure to change, either to sell to another company or create some kind of a corporate structure where one company is now a wholly owned subsidiary of the parent company. So there is quite frequently different corporate structure changes.
You may not know the answer to this. I'm told that for a wind or solar project, that each individual project is its own company. It's separated from the parent company, if you will, as a way of limiting risk. Is that true?
I mean, it's possible. Again, that falls back to the different corporate structure of having different subsidiaries, whether they're limited in nature, but it's not uncommon for a parent company to have a number of different facets of the parent company.
Do they have to come up with, do they have to tell the person that has the land that?
Yeah, that's a requirement of application as well to the AUC, is for them to describe what their corporate structure is.
And the reason I bring this up, you touched on this, where a lot of us are quite familiar with oil and gas and the structure of how they operate because we've dealt with it for decades. But in this instance, it gives a lot of people a great deal of unease if our local oil and gas company had a separate company for each well and controlled one well at a time and walk away. I mean, there would be a lot of people that would be understandably choked and upset about this.
Yeah, I can't comment to that, but I do know that there are different corporate structures with respect to the renewable energy industry.
Okay, and one last one, putting my counselor hat back on here. Have you seen any municipalities that end of life 25, 30 years from now, we're talking about the potential for a huge amount of volume coming to our landfills, negotiating a separate tipping fee, so to speak, for this onslaught 25 years later, and requiring an estimated volume so that we could plan.
You sit on waste management?
I'm an alternate now.
Yeah, that comment or that question has come up from time to time for municipalities. And again, I think that's a great subject matter to broach with the developer when they come in and they start to look at their municipal development permitting process. And or as a municipality, if you think that there's going to be that strain or stress on your current landfills, I would encourage you, to start to put your bylaws and policies and requirements in place now, looking to the future, in conjunction with having those frank discussions with the developers of, what their potential is, near term, midterm, and long term. Right?
Thank you.
This is two questions, but kind of one. Your office, are you available to come out and do public meetings so that it's very new to our county?
Yes, absolutely.
Yeah, we've got the wind farms that are adjacent, but the solar farms are pretty new. And then the second thing is from the Farmers Advocate Group, or if there's concerns, do you address concerns from adjacent landowners we have one adjacent landowner sitting in here right now on a
Yep, and we field calls from adjacent landowners proper, even, folks that are trying to do estate planning and those kinds of things. We are not a replacement for legal advice directly, but we can, have discussions with them and, maybe clear up some misconceptions and kind of walk them through the processes, if they want to participate in a process, how to do that through the AUC.
When you say the legal process, would the adjacent landowners have a right to talk to those three recommended lawyers, and they have that same right as them?
Absolutely. Yeah, the lawyer referral process in the Law Society of Alberta isn't limited to necessarily, direct negotiations between two parties. If you believe your rights are being directly and adversely affected, by all means, reach out and seek some legal counsel.
Yeah, thank you.
Yeah, for sure.
Mr. Chairman, could we ask Mr. Hayner if he has any?
That's just what I was going to do, sir. Mr. Hayner, Barry. I'm gonna call everybody by their first name today. Have you got you have one maybe going in beside you or proposed? Go ahead, got the floor.
Maybe get a mic to him. Sure.
Yeah. You can have
Thanks for
mine.
the opportunity to come and listen today. I've learned more in the last hour than I have in a lot of years. So I'm so happy to note that you have a summary that we can get through your advocacy office, because I kept trying to make notes here and I can't make them fast enough of the things I want to know. So between you and the county, I sure wish somebody would come up with a list of things to present to us as landowners to let us know what our
Dear, wow.
in such. But yeah, I'm a next door neighbor to a proposed site. And one of our concerns, myself and neighbors, is that, as you saw on your very first slide, the red area is some of the best farmland in Western Canada. And not only are our cities covering farmland every day, but now these solar panels are going to cover our farmland. I'm wondering if, I won't see it in my lifetime, but someday we might be looking for some place to grow food. All we got to do is look at the Netherlands, see what's happening over there. So that's definitely one of my main concerns, and another one is our property rights as a next door neighbor. Some of these sites, and I'm concerned about the people that are signing these contracts as well. Whether they're going, I'm not going to be here 25 years, but some of them will be, and I don't know what the cleanup process is going to be. So I'm very glad you're here. I really learned a lot. Thanks, Mr. Chairman.
So just as a response to that, thanks for the question.
Have you got cards?
Yes.
Would you, I think everybody would probably want one if you have enough, Barry and the whole board.
Yeah.
Okay, thank you. Go ahead.
And, thanks for that comment. It's very much a common concern that we're hearing from the agricultural community, both on the property rights and the fundamental conflict in the taking up of prime agricultural land for an industrial footprint. And my message to that is three things: participate, participate, participate in the AUC proceedings, right? Sign up as, your intent to participate. And if you're granted standing of full participatory rights, you can, do your own submission of evidence, cross-examination, right? It's a real quasi-judicial type of a process. But even if you do not get granted standing, you can still submit your issues and concerns and express to the commission how you feel that you're going to be directly and adversely affected, both by the taking up of agricultural land and any property rights that you think may be being diminished. So again, just participate in that process, because unless even municipal councils or members of the public, if you don't participate in those processes, the commission can only assume that you have no issues or concerns. And if you don't provide them with something to take into consideration in their adjudication of a decision, their hands are tied. They're not going to, assume that there's this issue or this concern or that objection. You have to tell them, right, and participate.
Have you heard of the AUC actually turning anybody down? Because there's been quite a few proposals. Have they actually It seems to me that it's, I hate to say it, but it's almost rubber stamped.
Recently, the Foothills Solar Project was not approved. It was declined.
And where was that in? Is because of the environmental?
Correct.
Where exactly was it in
Foothills County.
Foothills County?
Foothills, yeah.
Against the mountains?
No, it was straight south in central Foothills County,
Okay.
Frank Lake. And it was declined on environmental
It's
issues.
an environmental sensitive area. That was what I understood, right?
And Foothills County did participate with full participatory rights in that proceeding.
But that's the only one?
That's the only one to my knowledge in recent history.
That's been turned down. Well, I got one for you. I just want to ask you one question. How come, why would you not find what, okay, you're going to take up a whole quarter out here and your reclamation, why, if you get a price on the reclamation right now and it stays with the land, not with the landowner, it stays on the southeast, and your cost of living so that when 25 years from now or 30, when they take off, there's some money there to do reclamation on it because these solar panels, they just rent the land, they don't buy it. And then that way, then there'd be some cleanup and you wouldn't stick to like the county of Stettler or the county of Lacombe or the county of whoever with cleaning the thing up. I think that would be a heck of a way to go, actually.
Yeah, very good comment. And that's all going to be the devil in the details of the leasing agreement itself with respect to the provisions of assignment, right? So that, you know, it's assigned from one landowner to the next landowner to the next landowner and, you know, having it stay with the land.
20 people owned it in between.
Yeah.
And they got big bucks off it at the end of the day. When everybody else walks away, you'd have something there to reclaim this thing.
Yeah. So, and like I say, and that's the provision of the successors and assigners to whomever the landowner is at the time that could be on the hook for those end of life obligations. And then with consumer price indexing or any inflationary matters, many of the agreements that I've seen have that provision to review the security mechanism on a periodic basis so that it is current with any of the legislation of the day or the values of the day or the processes and the procedures of the day.
Anybody else? Barry?
Just to follow up, have you ever heard them discuss something like a surface rights board for renewable energy? Something that has more control than, AUC seems to be totally in control. They make all their own rules and they sign the check at the end. So I'm just wondering if they'd ever talk about a separate board for renewable energy.
Yes, that subject's come up from time to time of looking at trying to establish some type of a mechanism that's similar to the Orphan Well Association that the oil and gas industry has, where there's industry funding into, you know, some type of a program that would cover some of the delinquencies or the insolvencies or the defaults at the end of the day. So yeah, that discussion is happening right now.
Barry,
Yes, you know, we're in a NIMBY part of society now. And so now we talk about the production of power or whatever else is developed for the urbans to use. But then, you know, from an AUC perspective, we just went through where a big power line is going to be placed. Auxiliary power line is going to be placed within our county, but a major transmission line. And you're asked for your input, but your input doesn't go very far. And you talk about the filing reports and doing all these other things. That was never, like, that's not advertised well to people. So I really think it's important we get your group out to talk about this stuff so people become aware, because we had neighbors, all it does is get neighbors against neighbors. And we as a municipality are getting asked these questions for something that we have really zero control over. And we put our input in and it doesn't really make any difference at the end.
Information.
We had 5 different routes and all it did was just create a whole pile of turmoil throughout our county.
Yeah, so I guess my comment is to your view as to whether or not your input is considered and to what extent it's considered. I always fall back to if there's an absence of your input, there's nothing for them to make a decision on, right? Right. So,
It feels like it was absent.
right. So yeah, that's just, I understand and I empathize with that viewpoint, but adversely, if you don't provide any input, then you're not providing the commission with any mechanism to make a decision on your behalf.
That's a lot of these quite issue, these groups, NRCB is another one that we put input into and it doesn't.
And I'm happy to attend any community groups. I have in the past and deliver this same type of information to those that may have issues and concerns. I'm not just available for municipal council or special interest groups or anything like that. Yeah, if there's public interest, and I've gone out to many community groups already.
This was a real good, as Mr. Haynard said, this is a really good package and learn more in an hour than. Yeah, so.
Well, the one good thing, Mr. Chairman, I think we should point out is that this was advertised and it will be on our website for people to look at. So if you are talking to anybody out there, Barry, people can access this meeting on our website and be able to get it through social media. So they may have an hour in the evening that they're sitting around. They might be able to get it on their convenient time. So that's something you can let people know.
Yeah, and our office too, thank you for that. Our office too is available for, any telephone calls or, any consult or, advice. And even if you're in a conflict with the developer, we can come out and help do some, facilitated discussions and dispute resolution processes and things like that too.
Andrew, the YouTube of this meeting, does it show the whole slideshow and everything that we've been through?
You betcha. So the slideshow right sort of in the middle. Actually, if you look on your left screen, it would have looked like that. So that's how it'll be through the whole meeting.
So that does issue, put the whole thing out there too for the preliminary piece. But other people can come and ask the questions.
Good. Yeah.
For sure.
Are you,
Go ahead.
are you comfortable giving Andrew a copy of that slideshow? Just
No, absolutely. I'll just, I'll give you my card and then I'll send you a PDF of it and then you can post it.
I can copy it right off the flash drive too, and then it's.
As long as you PDF it.
Yeah.
Yeah, you can do that right now. Absolutely. Yeah.
thank you.
Well,
You're scratching your ear, or you?
I thank you very much for this, and I think I'd like to make a motion that we instruct administration to set up a date to have this as a public meeting somewhere in the near future for an evening meeting, maybe wherever that may be, what facilitates the best. Even if it is just an hour or an hour, a couple hours in the evening, go forward. I think Barry found it very informative. Let administration take it, work with it, and figure it out, but instruct administration to go forward with a public engagement of this particular.
Yeah, Quentin did a pretty good job.
yeah, we just did a public information session with Nehill County. So they just arranged one here last 3 weeks or whatever that we participated in. So they might be a good resource to tap onto for any do's and don'ts as well. So.
There you go. Yeah, you got her?
I got the
Is there
motion.
any other? Ask all our questions? Very good. I'm going to thank you very much for coming, and we learned more in an hour and a half than we knew about the solar thing, and it might be this, it might be that. And no, I think I'd like to have it down at the Ag Society there or somewhere where we had a little more room.
I've got a motion on the table for that.
You do?
Yeah, that's what I.
Good, done.
Members, Chair, thank you.
Thank you.
Thank you.
Good. Okay. Vote on your motion, no? All in favor? Carrie,
Pick up on that, Andrew.
Carrie for coming. And I was, if we could get a few cards from that guy and could pass them on, or you could, or whatever, that'd be great.
Nick can get the information to council.
Huh?
Nick can get all the information to us.
Okay. All right, well, we're moving on. Quentin, Agriculture Service Board Administration Report on page 8.
Barry, you're more than welcome to stick around. I know you're probably just missing it so much.
Trying to get my brain back functioning, normal stuff.
There you go.
Thank you.
Yeah, Larry.
All right, so just I guess a recap, I left in there the gopher control products we have available. Staff has been assisting administration with office moves, brushing and fencing, general cleanup. We had a bit of weather where we couldn't spray much, but we just kind of started roadside spray the first of the week, so we have one truck in 40-21 and one truck in 40-19. Just giving her. Our brush truck is out doing all the sites, inspecting and spraying where needed for what Public Works brushed all through the winter. And reclamation inspection, the whole reason this meeting got moved to 2 o'clock. I met with Ms. Lori Schmidt, the provincial inspector on the northwest of 28, 4118. And the inspection was good, I think. She kicked me out halfway through to finish her inspection by herself, but she's pretty confident. At this point, she's pretty confident it's going to pass and we'll get.
Was that one or two pits? Just one?
One.
Just one.
Was it the north pit or the west pit?
Northwest of 28.
No chance of getting the second one looked at, or we didn't want that?
Couldn't get it too further.
No, she's doing all the pits that were old and trying to get the ones off the book that were old.
So you sound fairly positive.
Sounds positive. I can't say it's going to pass until I get an email back from her saying it passed, but
How long did she say before she'd give it judgment?
she didn't say.
Tickle.
She had 4 more pits she was going to circle through on her way back to Edmonton, so she'll probably be a couple of days before she gets back to her office. Agricultural Service Board bursary, we had 5 applications. So a little further down, we'll see a request for decision on that. And I guess that kind of sums that up. I have been kind of working through some community events. This is one of them. I have it booked for the fall when I slow down a bit. If you guys want, we can push it through sooner, but we've already been talking about posting something. We had Darcy and Hannah and Delia for the Ladies Livestock Clinic, and it was well received. So we had talked about doing another one here for our people, but I wasn't going to do it until the fall when I slowed down.
Probably a good idea.
Well, it's, the only thing is this is moving along. Eh?
Yeah, true, but
I got a question back quick.
okay, go ahead.
Just on the spraying program, are you gonna vary hours with the temperature gonna be increasing, or are you gonna be shutting you down in the afternoons?
Well, they'll be shutting down as soon as it's too hot to spray. They're out there as pretty well as soon as daybreak hits. They start at 5 in the morning and they go till 2:30, 3 o'clock, but the last 2 days they've been doing full days, but if they get shut down from heat, they get shut down from heat.
Need somebody to move your report?
Any questions on it?
Any questions? James moved your report. Anybody got any questions? All in favor? Carried. Move on.
I just have a little update here for you for our declaration on drought. So as we know, you can talk to anybody in the county. The amount of moisture people received varies from very little to more than I can believe, but our average is probably sitting around that 1 inch 9/10. AFSC and RMA have been contacted. They have our letter and our media release. So we're just kind of in a hold right now. There are 3 counties that have declared: Painter, Vulcan, and Stettler, as of, when did I do this report? Last Wednesday. So yeah, I'm just kind of monitoring things, logging what crop conditions look like, forage conditions look like, pastures, that sort of thing. And you'll start seeing a lot more of these maps. I got 7 maps attached to this memo. You'll see a lot more of these maps to kind of show how things are progressing or delaying further.
Just if I could, just a minute. I got Larry first.
Just a question back through administration. RMA has been contacted and Alberta Ag, you said?
No, AFSC.
AFSC. So should we be sending a letter to our Minister of Agriculture and to our MLA?
Certainly can, yeah.
I think we should, that's through the elected officials too.
You make that
I'll
motion.
make that motion.
Okay.
We'll go the motion so staff knows.
You want to make that?
Okay, I'll make the motion that we
Go ahead.
send a letter to our Minister of Agriculture and our MLA in date order, just in regards to this, calling this and why we called it. So it gives a background, and that we're still don't feel, even with reports of 6 inches of rain in some places, that we're certainly out of the woodwork in this disaster.
Any other input? All in favor? Carried. Or James?
So, Quentin, we're looking at this map and now, what is the norm? I guess is what this shows us what we've got, but is okay, keep on. What did we get last year? This is once in 50 years. What did we get last year? What did we get the year before? Where, do you know what should we be at by this time going forward? What have we typically been at?
We didn't get a lot more last year than we did this year.
Okay.
Clear a drought, but we were definitely dry last year.
And the reason I ask that is because it can be a cumulative effect, right? If we didn't get any snow cover. We had that gentleman that came in the one time and gave us there was quite an interesting talk about moisture and how it was over a longer period of time and the cumulative effects, but I didn't take enough notes, I guess, to figure out what we should be at.
Ralph Wright is who that was, and that's who I get these maps from. And I can, for next meeting, maybe do a 5-year snap on what we look like year to year on the different maps you're seeing today. But
what would be a good millimeter response for June 21st, 23? Where would we be happy at?
Of the spring wheat moisture, you should be, most maps that they're putting out, green is normal.
Okay. So 120 to 140. If we had 120 to 140, we would be laughing.
Yeah,
Okay. Okay.
definitely.
We are at this point,
Even 80 to 100,
we should be at.
even 80 to 100 for us would be
Okay.
based on spring wheat soil moisture. I'm going to base that on,
Our snow cover was what we get to go for. Okay, that's fair enough. Thank you. That's all I was.
Tell you one?
Why? Oh, yeah.
Okay.
Nobody cares about Edmonton and Calgary's moisture, I guess.
They don't grow anything to eat there.
those aren't agriculture spots. right? That's all asphalt.
If you eat, you're involved in agriculture. Haven't you heard that before?
There's no spring wheat grown in the city of Edmonton. It's all asphalt.
It is.
Never seen ever.
It's at the airport in the ditch. I've seen it.
Except, we,
Go ahead.
Yvette and I had met with, the province. And she said a lot of the office spaces in the cities now are now vertical greenhouses.
Yeah.
So they will become more agriculture.
But their water comes from a way different source.
They shouldn't collect water though.
You're right, I agree.
Okay, fair enough. Thank you.
Moving on.
Any other questions on, yeah, I'll just keep putting the update in there as we go.
Receive it for information, Paul. All in favor? Carried. Moving on.
Right, so now I have a few requests for decisions. First one is lease lands. Just annual discussion on this one. I didn't actually change anything on this because we did have, not that long ago, some pretty heavy discussions in committee of the whole, so this one I didn't change at all.
Didn't change it at all, or if it's changed? James?
I'll receive that one for information.
All in favor? Carried. 22.
That's not a receive for information, is it? That's a approve as presented. That's a,
We're not changing it.
Accept as reviewed.
yeah.
Would be the other- Just because we will throw another stamp on the bottom saying reviewed this date, this motion number.
Okay, yeah.
E2.
So we don't need to redo that or you're,
As long as he's okay with it, you're all
I'm
okay.
okay with it.
Okay with it? Okay.
Accept it as reviewed.
Go ahead, Glenn.
Okay, so the next one is policy 3.6, pest and nuisance control of the county right away.
Now, Mr. Chairman.
Go ahead.
Mr. Stolberg had sent out a email. Does anybody remember his email? Does anybody have his email that he wanted us to discuss? Because he, I think, went to the Central Ag meeting.
Yeah, he went to Central Ag meeting because I couldn't go.
So
And he had a write-up, he had a report on it, yes.
I'm trying to look and see, does anybody remember what he put out there?
Yeah, I haven't had any.
You have it?
Yeah, well, I just, the note was sent out on June 13th.
Yeah,
to
thank
the
you.
Trapping and Wildlife Control and Municipal Right Away from ASB. So his comment was that he knew it was passed to form a policy to permit trapping wildlife like beaver and muskrat in the county right away, so they don't compromise the integrity of the roads. I think he was just looking for a progress update at this meeting.
Okay,
And that was in light of that Central Region ASB meeting.
okay. And what was the other one he had?
That's the only thing I had in that email.
He had 2 emails, I think he sent out that he wanted
The
to.
other one, the reports which are coming up.
Okay.
It was a report on the meeting. Everybody all right with that one?
Is there any changes to this one, Quentin?
No.
once again, it would be accepted as reviewed. I'll give that motion.
You do that?
I would.
Oh, you will? Okay. Very good. Yeah, receive. Okay. All in favor? Carried. Moving on. 8.4. First reading.
8.3 Animal Health Act, 3.12. So again, we did some revisions to this last year when we started having, right before we had flu outbreaks. So this one I actually haven't tweaked at all because it had some revisions at that point. It's just annual review again.
Justin, you gonna move it then?
I'll move it that we accept as reviewed.
Accepted as reviewed. Anybody else? All in favor? Carried. Moving on. Now we're 8.4. First reading award.
I guess I can start with this, but I'll let Mr. McKay take it. We reviewed the fire applications. All very good applications that were received. We did have some requests for clarification on some of the language. So I think we got a good idea of what we wanted to do. So But it came down to Mr. McKay's decision. Mr. McKay?
Yeah, I thought this one was probably the best, and saying that, a lot of them were, 3 out of the 5 were going to, looking towards vet or vet tax. This one wants to be a vet in our local area, so this is what kind of swayed me the most. One wanted to be a banker or something with AFC, which I'm thinking, well, I don't think it could be agriculture, but it's a money thing, but this one by far was I thought the best one. And she wants to work in the community with big animals.
Mr. Chairman, I know this young lady and
You want to make a motion?
she definitely, she could probably run the farm by herself, I think. And I have no doubt in my mind that if she puts her mind to it, she would do whatever.
I know her too. She's a go-getter. So you made the motion. Oh, Paul made the motion? Okay. Okay. All in favor of that motion? Carried.
With that being said, I will invite her into the next council meeting for a
Report.
Council or ASB?
council, just because it's the next one, right?
Sounds good. Everybody's in favor of that anyhow. Okay, financial up to 2023 financial. On 10.
All right, so financials, nothing has gone sideways. I guess I can tell you that. We're taking along.
We're on budget?
We're on budget, yeah.
Okay.
If you look at total budget spend right now, we're at 24%. Remembering that there's 2 months not in here yet. So we're pretty well on track. And I just started spraying, which are my big accounts. So this doesn't show any chemical coming out of my herbicide budget yet, because it only just come out of the truck on Monday. Nevis water well was overspent, but we had to do a little repair on that. Otherwise, we're good.
Ernie? You're gonna receive it for information? Or remove it? You move it, all in favor, carried. Information items is none. Committee, East Central Region, Ag Service Board, Government. School Works has report.
Mr. Stolberg did text me late last night saying if there's any questions on these 2 reports, I can text him and he'll answer me. But they're here. You guys have read through them. If you got any questions.
Any questions on them? Message?
I'll give you a motion to receive for information.
Both of them?
I just have a question, which probably Les can't answer, but beekeepers have expressed an interest in use of highway right of ways. Boy, you even go by quarters where the bees are. And I don't know how the losses don't, because they have a flight path right across the highway.
Losses would be a little high, well, that's up to them.
But it is like there was bees along Highway 12 at one point. I think somebody figured it out because it was just, you couldn't really keep your windshield clean. Every time you went out through them, and it's numerous times a day.
I wonder if they're thinking of maybe like some of the secondary highways, because I mean, if you were on.
If you put that on Highway 12.
Place, I mean.
Yeah,
They don't go on like crazy.
it's Highway 12.
Yeah.
I know it's a little too busy, I think.
I'll be honest, and it kind of reminds me of the situation of when you graze the ditches. I mean, it's sometimes you might need to do it, but I'm not so sure that it's most advantageous, right? I wouldn't want to be grazing Highway 12 too badly.
That's one thing I did pick up.
Yeah, there would be a risk to it. Anyhow, you made the motion for both of them, though, right?
Yes.
Okay. Any other questions? No? All in favor? Carried. Next meeting is June 28th.
Not today.
Is it not today, isn't it?
That's supposed to be July 26th. not June.
26th, is it? Okay. July. And the other ones, the seminars and that, there's no dates on them yet, but as they come available, you're gonna send us a thing where they are and what they are.
And a solar farm one, do we think we can?
If you guys want it sooner, I'll look what his schedule's like and we'll do it sooner.
I think sooner is better.
I think there'd be a lot of public interested in it, and I think the Ag Societies would be more than happy to host us for something like that.
I would think that would be the venue for it to get enough seats, because I think you're gonna have a few.
Yeah, no, I, unfortunately, I know you've got a pressing on almost everything and I get it. Unfortunately, this one is one of those ones that it's gonna come whether we like it or not, and I'm with Larry, I think it's coming sooner than later, so.
Okay. You're gonna try to get a date here fairly soon?
Yeah.
Paul?
I would just ask the rest of the council, but I don't know whether it's even a possibility, but because that one farm is coming up around Red Wolf, I have had a few calls that I've tried to take, and I'm just wondering if we could hold it at the Red Wolf Hall being.
Well, I don't mean, but we also had the one south of town and I've been taking a bunch on that one and questions on that, so.
I've taken calls on both of them, and
So I think the Ag Society might be the better places for.
Ground.
Just wanted to throw it out there.
No,
I think we'll have an Ag Society, unless there's unless you really got resistance to it. I like to see stuff in your area, but
Big and central.
we have this one and that one both, and the other one sort of in between.
Well, interesting enough, they have a huge facility planned. My brother Tony, just south of his new house, they're putting a big facility in. The landowner kind of changed hands and now the new landowner is possibly putting up a solar facility, so.
And we got that community involvement in Red Wolf coming up in September, but I'm sure we're gonna have to field a lot of questions.
I'd like to have this before so that community involvement just isn't.
Hold it if I could. I think what we just need to caution any counselor when you are speaking of this, that you take it with a
Neutral.
just say, we're getting the information out there. The reason we have to do that, we will sit as the MPC board making a decision, and I just don't want us to have any conflicts going forward.
Okay. Justin?
This is more administration. Do we have the ability to record that, similar to what we did for those that can't attend this engagement?
Done that in the past. It's tricky, but it's doable.
Yeah, it's definitely a little trickier.
And
Because right here, we've got the equipment set.
we have to, not a showstopper, but it's an interesting option if it's available.
Yeah.
Not that these other ones aren't important, but I think I'd like to see a motion to do the solar farm one.
I think
by
we did.
itself. So Quentin has direction to get on it and get it going.
We did a motion with the presentation, so.
You already have a motion.
So I think we're okay.
All right, then we just need somebody to move. Ernie, you're up. Move these for information then, till we get a date set on them. All in favor? Carried. In-camera session? None. Need one more thing. Justin,
The motion for adjournment.
favor? Carried.